Good morning, everyone. Thank you guys for being here. I'm really glad to have this opportunity to talk to you today about non-judicial foreclosures. So as Milton said, my title is, Where Are We Now? In order for me to answer that question, I have to give you some background information and a little bit of history about how we got here. So I have a few parts of few sections within my presentation. The first I'm going to do is a brief comparison of judicial versus non-judicial foreclosures to give you kind of a baseline. Next, I'm going to give a brief overview of the Sakal court case that deals with non-judicial foreclosures. Then I'm going to actually discuss the non-judicial foreclosure bill that passed last year. And I'm also going to talk about some risks and rewards that comes with doing non-judicial foreclosures. And then at the end, I'm going to kind of give you a couple takeaways from the presentation. So we'll get started here. The comparison between judicial and non-judicial foreclosures. So judicial foreclosure action is one that takes place within the judicial system, right? So there's court oversight with a judicial foreclosure. This means there's a judge overseeing the case. The judge is ensuring that procedural requirements are met, the rules and the laws are followed. Whereas with the non-judicial foreclosure, there's no court oversight, right? Because the foreclosure takes place outside of the judicial system. So there's no judge, no court to review the case to ensure that procedural requirements are met. Now with judicial foreclosures, as you can see, they take a long time, 12 to 24 months to complete. And it takes longer because attorneys are at the mercy of the court. Okay? So sometimes during the course of a judicial foreclosure, you have to schedule a hearing, which means you have to go to the court and ask for a hearing date to be assigned. Court calendars can be very, very busy, so sometimes you get a court date 2, 3, 4 months out. So that waiting period contributes to the length of time for a judicial foreclosure. Whereas in a non-judicial foreclosure, it takes an average of about 6 to 8 months to complete because there's no court. You don't have to schedule hearings, you don't have to go to court. Significantly less time. Now with a judicial foreclosure, you have about $7,000 to $10,000 in legal fees, plus commissioner's fees and costs. It's a lot of money. Now, whereas in a non-judicial foreclosure, it's about $3,000 to $5,000 plus your publication costs. Okay? There's a lot less attorney involvement because there's not a need to go to court, and thereby it reduces both the dollar amount and the time it takes to complete a non-judicial foreclosure. So before I get into the actual bill itself, I want to give a quick recap of the Sakal court case. Is anybody familiar with that name, Sakal versus Ao'ao Hawaiian Monarch? A few of you? Okay, what about SB 551? A little bit? Okay, good. Okay, there's some of you out there. Okay, so basically in this case, Sakal versus the association, which is Hawaiian Monarch. Hawaiian Monarch conducted and completed a non-judicial foreclosure against Sakal's property. So the key is that it was completed because there was a transfer of title. So essentially it took away title from, or ownership from Sakal. So Sakal turned around and sued the association for a wrongful foreclosure claim. So basically, Sakal was saying, look, you guys didn't have the authority to conduct a non-judicial foreclosure. Your governing documents didn't give you the authority, and neither did the law. So I'm going to sue you to try to get my property back. So in the court's words, the court concluded that, quote, a power of sale in favor of a foreclosing association must otherwise exist in the association's bylaws or another enforceable agreement with its unit owners in order for the association to avail itself of non-judicial power of sale foreclosure procedures. What does that mean? Basically, it's saying that, court is saying that the association did not have the authority to conduct a non-judicial foreclosure because the association's governing documents did not have a provision or any type of term in there that expressly granted the association the authority to conduct a non-judicial foreclosure. So the association's governing documents need to have a non-judicial foreclosure sale provision, what I like to call the buzzwords, okay? So if you have these buzzwords in your project documents, you may have the authority to conduct a non-judicial foreclosure. But what are those buzzwords? Non-judicial foreclosure, or you might see buzzword of power of sale foreclosure. okay? So if you see these buzzwords in the association governing documents, that would expressly grant the association the authority to conduct a non-judicial foreclosure. So as you can see here, I provided an example so you can see how it's being used. This example contains the buzzwords. The lien of the association may be foreclosed by action, which is a judicial action, or by non-judicial or power of sale foreclosure procedures set forth in Chapter 667. Now, Chapter 667 is the non-judicial foreclosure statute. So this example gives you an idea of how those buzzwords can be used in your governing documents, and that would tell you that the association does in fact have the authority to use non-judicials. So how I like to sum up the case in my own words, if the governing documents do not have the buzzwords, you can't do it. Bottom line. So because of the court's ruling, a lot of people in the association industry went into a frenzy, and SB 551 came to life in order to correct the court's ruling. So SB 551, the non-judicial foreclosure bill, became law without the governor's signature, and it's now referred to as Act 282, which again amends or clarifies Chapter 667, which is the non-judicial foreclosure statute. So the bill attempts to clarify in stating that associations do in fact have the authority to conduct non-judicial foreclosures, whether or not it's specifically stated in your governing documents. This bill also contains some prohibitions, such as you cannot conduct a non-judicial foreclosure if your lien balance arises solely from fines, penalties, legal fees, or late fees. So stated in another way, if an association is going to non-judicially foreclose because of a delinquent balance, that balance must be because of unpaid common expenses, such as maintenance fees and association dues. The bill also contains some consumer protections, such as non-judicial foreclosures cannot be used if the owner is deployed outside the state of Hawaii. That makes sense to me. They're not around. SB 551 also has some notice requirements in that the owner has the right to request mediation within 30 days of receiving that notice. I think of this as another consumer protection as well, because it provides the owner an avenue to kind of bring the parties together and come up with a resolution. And if the mediation is requested within 30 days, you actually have to complete the mediation within 60 days. Okay? So if the 30 days has passed and the owner has not requested mediation, then you can proceed with a non-judicial foreclosure under this bill. Now, this bill might be sounding okay to some of you, and like, okay, associations can do non-judicial foreclosures, but just hold on. There's some possible challenges to this bill, and I've come up with 3 that I wanted to discuss today. Retroactive clause, due process, and interfering with a private contract. Those are the 3. So first, as to retroactive, SB 551 applies to all past completed non-judicial foreclosures. So if your project documents did not or do not contain the necessary language and the association has completed a non-judicial foreclosure, then associations are safe, at least for now, for being sued for a wrongful foreclosure. So essentially, the challenge under the retroactive clause means that the law took away an owner's ability to sue for wrongful foreclosure. It took away an owner's claim. Okay? So it clawed back in time and said, okay, associations, you guys are protected. But it clawed back in time and said, owners, now you can't sue. So you also have the argument, on the other hand, that the bill is technically not retroactive, but it's just trying to clarify the legislative intent. And that intent has been this entire time has always been that associations do have the authority to conduct a non-judicial foreclosure under the statute 667. Okay. As to the second possible challenge is due process. I think most of us will know that rooted in the United States Constitution is the right to due process. That's the right to receive notice. So if your governing documents do not expressly provide for this non-judicial foreclosure, then the owner has no notice that the association can actually use a non-judicial foreclosure. So if there's no provision in your governing documents, owners will not receive due process notice. If you buy into an association, owners are not going to know this possibility exists. Again, because if it's not in your project documents, how is the owner going to know? But on the other hand, a due process challenge is one that's brought against a state actor. So whether it's the state government or the federal government. So the challenge may not come to light, at least maybe not right away, because in order to do so, someone would have to file a lawsuit against the state for enacting this bill. Okay. And as to the third one, interfering with a contract, case law shows us that associations' governing documents are a contract between the association and the owner. So again, your contract, your governing documents do not have a provision in there, then how is anyone gonna know? The owner's not gonna know. There's no contracting, there's no provision, there's no terms in there for the owner to go, okay, I understand you can do this and you can't do this. Okay? So it's kind of conflicting between the bill saying, no, you don't need it in there, but case law telling us, yeah, you kind of need your provisions in a contract. So now I'm going to get into the risks and rewards. So if you're following along, a reward now is, hey, if you don't have it in your project documents, then you can conduct a non-judicial foreclosure. Non-judicials are less expensive and less time consuming. So these are all rewards. But I want to focus on the risks. And first risk I'm thinking is the challenges to the bills, okay? These challenges could take years to complete, and there's no way to predict the outcome of these challenges. But I believe the most important risk to consider is the effect on insurance coverage. So you have insurance carriers that may or may not cover claims relating to both judicial and non-judicial foreclosures. In fact, there's at least one insurance carrier that's not covering both. Okay? So even if an association is covered right now, you can't assume that you'll be covered at the time the claim is made, because the directors and officers coverage are claims made coverage. How many of you are familiar with that term? A few of you, okay. So as an example, right now the association has coverage today. We go through, we do a non-judicial foreclosure, and let's say in 6 months, it's completed, great, the association got their money back. Maybe a year later, insurance says, okay, we're no longer covering foreclosures. Maybe a year and a half, 2 years later, an order comes in and says, now I'm gonna sue you for wrongful foreclosure. You have no coverage at the time the claim was made. So the association is now the one who's gonna end up paying for defending that claim. There's no insurance to step in and help. Okay? So because of this, it's extremely risky to conduct a non-judicial foreclosure, given there may not be coverage for that claim. But on the other hand, judicial foreclosures may be excluded as well. But again, if you recall, I had talked about the fact that the judge is overseeing the case to make sure procedural requirements are met and the rules and law are followed. And because of that court oversight, the association has additional layers of protection that may insulate them from a wrongful foreclosure claim. Because all along you had a judge telling you, okay, you can proceed, you can move to the next step. So it's an additional coverage. I actually attended a CA seminar in June of last year, right around this time this bill was coming out. And David Major, who is an attorney who defends associations for wrongful foreclosure claims, pretty much just said flat out, don't do them. It's not worth the risk. So insurance coverage is a huge risk to consider. So associations may or may not want to use non-judicial foreclosures as their collection method, but boards, you should seek legal counsel and talk with your insurance agent. One of the big impacts that's going to have is if you don't do non-judicial foreclosures and you have to go with a judicial foreclosure, you're going to have to budget for an increase in legal fees. You're going to have to budget for the fact that you're going to have to carry the debt for a longer period of time before you end up recovering under a judicial foreclosure. So I'm just going to repeat myself at the end because I think I need to stress this part, and this is my takeaways, okay? Contact your association's attorney, get an opinion from them. They will lay out the risks and rewards in even more detail for you so you can make a better judgment. And again, contact your insurance agent. Coverage, yes, no, maybe not. Seek out your experts in this area. And that is the end of my presentation, so thank you.